Good morning. Today is the 5th of August, 2020. It is 8:45 a.m. This is a meeting of the Grimes County Commissioners Court for a public hearing. We are at the 114 West Buffington Avenue Annex in Anderson, Texas. We have called the meeting to order, and we are now going to move to agenda item number 2. Consider the application for and hear any protest to the following proposed replats in Precinct 1. And we have 3 requested replats. All 3 are in King Oaks. First one is King Oaks Section 1, Lots 7 through 9, located in the Gwen Morrison Survey Abstract 326 as recorded in volume 1204, page 197 of the GCRPR. Shall we take these one at a time, Mr. Walker?
Yes, sir.
All right. So we're now talking about Section 1, Lots 7 through 9.
This replat, they're actually combining 3 lots to make 2 new lots. This is at the cul-de-sac at the end of Abbey Lane. They have met all our criteria, and we're recommending that it be approved as presented.
Commissioner Mallett, they're up in your part of the world. Any thoughts or comments?
These are pretty standard, increase in the size of the lot of each lot.
Mr. Walker, are new fees applying to these replats?
Yes, sir.
Okay, and people were made aware of that?
Yes, and the fees have been paid.
Okay.
We had a rush of replats right after the fees went up.
All right. Then let's go to the second King Oaks, Section 1, Lot 17 through 18, located on the Gwen Morrison Survey, Abstract 326, as recorded in volume 1204, page 197 of the GCRPR. And hear what you have on that one.
Okay. This replat is actually Bob Leeper's property, and he's here to answer any questions you might have.
Okay.
They are taking 3 lots and combining them into one of which they already have a house on. And that's, your house is faces on Westminster, correct?
Correct.
Yeah. The configuration that they will now have roads on 3 sides of their property. No issues with that. And again, they have gone through the process and complied with all our regulations, and we're recommending that this be approved also.
Mr. Leeper, is your homestead on one of these properties?
Yes,
Okay.
on 119 is my homestead.
So, as a commissioner's court, we were kind of counting on 3 taxpayers being on this property instead of 1. Would it be okay if we just take your taxes times 3 and make it in that fashion?
No,
With
sir.
that? Okay.
I want to help all I can, but
Not that much. Okay, well, I just wanted to see how helpful you wanted to be.
Well, yes, sir, there are limits.
Okay. So, Mr. Walker and Commissioner Mallett, you see no issues with those? Okay. And then finally, our third is King Oaks Section 2, lots 256 and 257 are located on the Gwen Morrison Survey Abstract 326 as recorded in volume 1239, page 402, volume 1581, page 202 of the GCRPR.
And Judge, I'm going to ask that you table that item. They did not get the final plat and all their, the Mylar and paper copies, everything we needed in time for the meeting today. So we will bring that back up at a future date.
Is it correct for me to understand if we do indeed table this, that the 30-day clock starts over upon their submission?
I'll need to look and see, the advertising has been completed as per the state law. If we bring them back next week, we may not have to re-advertise because you got it within 30 days. but of course, the 3 weeks only takes 21 days. So I'll have to check the dates on that and see if it needs to be started over, or we can just continue on the basis.
Well, my concern was with the way the legislature changed the laws this last session, that if we didn't take action, it automatically occurs in 30 days. Does this fit in that arena?
We get an exemption if the applicant does not provide all their documents in a
Yes, sir.
timely manner.
Okay.
So I'm not concerned about that aspect of
Okay.
it. But that 30-day window, I'll need to analyze and see if we need to actually re-advertise again, or we could just pick it up next time.
Okay, and if we needed to re-advertise, would that be the obligation of the requester?
That would be my recommendation.
Certainly.
To be honest, we haven't had this situation come up before, and they paid their fees, they've been working with us, but, and I told everybody, last week, I sent a note out to everybody for these three plats, and said, okay, I've got to have your originals fully signed and the paper copies by Tuesday afternoon, because it's our only hearing on Wednesday morning. And two of them came in, brought all their stuff in a timely manner, and the other one never showed up.
Dare I ask our county attorney, do you have an opinion on the county's obligation if we exceed the 30 days on this request from the landowner?
Judge, I'll tell you that I always get out the local government code to be sure that I've got it right. I think Harry's hit it on the head, and that is, I don't think there's a provision that speaks to if they make application, we do the advertisement, then they don't get all the documents together, can we charge them for the additional cost? But it seems to me at least equitable that they would pay that cost. So,
Well, and also my concern though is that if they were to perceive that, well, I submitted this and they didn't approve it or disapprove it within the 30 days, that
Right.
it automatically goes through.
right, I think you're talking about a change to the plating. I don't know if that same change was made to replatting.
Okay.
But Harry's on top of it, and
Okay.
we'll be fine.
All right.
I think John is correct. The replatting has a different timeline.
Okay.
Just original plats, the 30-day provision provides, but even in that, if the applicant doesn't produce all the required documents in a timely manner, that time gets extended. So I don't think we're in trouble there. I'm just not sure if we're gonna be within that 30-day window.
Okay.
Because it's the advertising portion, and we've complied with the advertising portion, so we're getting into kind of a murky area that I'll get with John and go through and make sure if we need to re-advertise again or what we need to do in this case.
Okay.
Again, at this point, I don't know when we're gonna see their plat.
And part of the advertisement is for the public hearing, right? So if we move
The
the public
advertising
hearing, we
is
might
for
have
public
to,
hearing.
yeah, we might have to re-advertise for that.
I guess that would be an option that y'all could go ahead but we can hold the public hearing and just not take action on the plat itself. Again, I don't have copies to present to you.
Well, I guess, yeah, this is the public hearing for it, I guess technically, so then we don't have to prove it now. We can look into possibly proving it later without the public hearing.
We could probably make that argument.
Yeah.
I just didn't want somebody playing gotcha, on this. This is a public hearing, be a last call for comments. Are there any comments? And finally, any further comments in this public hearing? Hearing none, we'll go to agenda item number 3. Is there a motion to adjourn?
Move to adjourn.
Second. There's a motion before the court on agenda item number 3 by Commissioner Mallett, seconded by Commissioner Dobianski. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed? Motion carries. Let the record show that Commissioner Walker was not present for the public hearing, which she is here now.